and various theories that deal with it. I'm trying to present a PPT. I think the PPT is visible. There are two limitations when I start. One is that if there is a power cut, then my internet connection will be also disturbed for 2-3 minutes because I am connected through broadband. So please bear with me for 2-3 minutes. Second is that sometime it so happens that when I move the PPT from my side, the PPT does not move from your side. So each time the PPT is moved, I will inform. If the PPT does not move, please any of you please indicate. Otherwise, I will presume that the PPT is moving. The topic is clear, that free speech on social media, theoretical perspective. The credit to frame this topic also goes to Professor D.P. Verma sir, because I have proposed a novice type of topic, but then this topic sounds very well. Thank you again, sir. The questions that I am going to discuss today is why and where is free speech provided? What constitutes social media, its significance and impact? What are the theories for limitations of free speech? When to criminalize it, when not to criminalize it? Are these theories equally applicable for social media? How is the concept of free speech different from USA? Social media engagement by Facebook, Twitter, YouTube, WhatsApp. How law moves in case especially for FIR arrest? And then finally, what is our responsibilities? Now, why free speech? Free speech, there are many theories why free speech. You can find maybe 10 of such theories. I have tried to found 5 such theories. First is to investigate truth. What is the truth? सच्चाई क्या है इसको जानने के लिए free speech is essential. And therefore, this does contain the opinion of other party, and that happens every day at our home. When there is a quarrel between two children, we try to know the truth, because someone who is weeping hard, maybe he is at fault. So to investigate truth, free speech is essential. Second is citizen participation in democracy. Well, democracy means for the people, by the people, of the people. It is an old theory. We choose our representative at various level, maybe at state level, at central level. The representative go to the parliament or go to the legislature, and then they make law. But then democracy has a changed meaning now. And the changed meaning is that citizen has to participate in the democracy. Of course, there are representatives. So what are the laws being made? Representatives will decide, but then we will also decide. So the free speech is essential so that we can participate at every level of democracy. So it is essential for citizen participation of democracy that makes democracy a far more vibrant democracy. You'll find that these days laws are uploaded, bills are uploaded on the websites of Lok Sabha, and or maybe when it goes to the parliamentary committee, and then people are asked that to give them their opinion. So this is participative democracy. Third is right to self-development. Now free speech is for self-development also. Maybe I don't want to tell anything what I am doing, but I may write only a diary. Many of us write diaries. Indeed, 13-year, 14-year old children also, they also write diaries. They keep it safe with them, they keep it confidential. But then this is another exercise of free speech, because it is essential for self-development. So diary writing is a mode of self-development where we examine our strength and weakness without hesitation. Fourth theory is to question the government. Not only the government, to question political leaders. Not only political leaders, because government and political leaders are always soft target. Also powerful people in media, powerful people in business, powerful people in religion, powerful people in academia. Free speech is essential to question all powerful people, to make them accountable, to make them responsible. Because the government is most powerful, therefore we all have right to ask questions, many uncomfortable questions from the government. It is the duty of the government to accept all those questions, sometimes maybe inappropriate questions, sometimes maybe offensive questions, with great hurt. Fifth is safety wall. Free speech is a safety wall, especially dissent. Dissent is a safety wall. Safety wall, we must have seen the cooker. Cooker contains a safety wall. If there is no safety wall, cooker will burst because of pressure. It informs, it gives us timely information that yes, enough pressure is there, and therefore we take special measures. Similarly, free speech and dissent both are type of safety valve. If there is no free speech, if there is no right to dissent, democracy might burst. Democracy may not function. Democracy will turn into any other form of rule. So it is a safety valve. So there may be 5 theories which conveys why democracy is essential. Of course, it is not the best form of governance, but then whatever form is available, this is one of the best form. Now, where to find this freedom of speech and expression? कहाँ है अभिव्यक्ति की स्वतंत्रता? So number 1, it is natural. एक बच्चे का जन्म होता है, वो रोता है. He declares that he has come to the earth. So it is a natural right. This right is given by God, and therefore it is a divine right also. We need not to take a special type of medicine. Artificially, nothing is required to be done so that we start weeping, we start laughing. It is natural. It is divine. So the freedom of speech and expression is natural and divine. That's why it is a type of higher right, and it is universal in nature, because this right given by God, given by nature, is universal in nature. Be it Africa, be it America, be it Sudan, be it Iraq, be it Pakistan, be it India, be it Bangladesh, be it any other country. That is why freedom of speech and expression is universal in nature. And then there are modern sources of this right, but I will just remind everyone that there are ancient incidents also. Take example of Kans and Shishupal, and Krishna and Shishupal. Lord Krishna has told Shishupal that if you want to abuse me, you abuse me. I will wait till 100 such abuses. So this is the level of dissent that Lord Krishna has been shown to us. Another incident can be taken from Lord Rama. The incident may not be very good, may not be very pleasant, but that is ultimately an incident which is found in our epics. When Mata Sita came to Ayodhya, one of the residents had some objection on Mata Sita. Lord Ram was ultimately the king. He could have taken any action against that person, that citizen, but he has not taken any action against that person. He tolerated with that. So Indian wisdom indicates that tolerance is our blood. Now, coming to the modern sources of free speech, we will find one of the best sources, Universal Declaration of Human Rights. Article 19 itself, incidentally, but Article 19 comes with various restrictions. In ICCPR also Article 19 is there, but that also comes with restrictions. In our country, the source of freedom of speech and expression is basically fundamental rights in the Constitution of India. Now, where this freedom of expression finds mention in the Constitution, it is not just one place of fundamental right. We will find that there are more than 3-4 places where freedom of expression in one form or other form finds recognition. For example, preamble. And preamble talks about liberty of thought expression. In the very first page, our framers of the Constitution has given it such a great weight. In the preamble it is found. Then in the privileges, Visheshadhikar for our representatives under Article 105 of the Constitution of India, 194 of the Constitution of India. Special rights have been given to them besides fundamental rights because they represent ourselves. Then fundamental rights I have already discussed with you, Article 19. Then fundamental duties, though it directly does not talk about right to speech and expression, but then you can find some clue under Article 51A Clause H. 51A Clause H talks about scientific temper, spirit of inquiry and reform. Development of scientific temper is done by discussion, the way we are doing now. And spirit of inquiry, to ask questions from government, questions in the classes, questions in the discussion, for which the democracy is, and to make people accountable. And ultimately not only to ask questions but also to reform. So 51AH talks about inquiry and reform, which is done by freedom of speech and expression. Then 361A, that anyone who publishes the records of the proceedings of parliament and the legislature, he gets some immunity if it is not malified. 361A. Then in the concurrent list under entry 39, newspaper, printing press, books, they are provided for which the laws can be made. So we can find that our framers of the Constitution in 1950 itself, or maybe parliamentarians later on, 361A was added later on, they were so much concerned for freedom of speech and expression that they have provided it in more than 2-3 places. I doubt there is any constitution in the world which makes such a comprehensive provision for freedom of speech and expression. And the reason is simple. Reason is that we had been colonized by the British and they have suppressed our freedom of speech and expression. So we wanted to make it very clear that our freedom of speech and expression is ensured at every level. I'm trying to change the PPT. Yes. Now what does Article 19, thank you for bearing with me. What does Article 19 provide? I think the PPT is not visible. Is it visible? PPT is visible or not? Is it that is visible? But okay, let me see. No, but I have opened another PPT. I don't know why is it not visible. This Article 19 and up to A to G, is it visible or not? Okay, now okay. So Article 19 contains these rights: freedom of speech and expression, right to assemble peaceably, right to form association, right to move, right to residence, right to profession, occupation, trade and business, So freedom of speech and expression we are discussing, we will further discuss. But right to assemble is another form of freedom of speech and expression. Now today itself we have assembled, and we have assembled through virtual means in the under the banner of Aacademiic. So we have right to assemble, and with the help of WhatsApp, with the help of other social media, with the help of Google Meet, it is possible. Right to form association. Now various WhatsApp groups are created. Sometimes Facebook groups are created. Groups are created on Telegram. They are a form of association. No formal registration is required. So these assembly and these associations are part of our fundamental right. Then lastly, profession, occupation, trade and business. Can the social media be used as a means of trade and business? Yes, the answer is yes. On the Facebook you must have seen people are selling goods. So if they are selling, it is a part of fundamental right under Article 19(1)(g). If some advertisement is being given, that is not just a commercial type of activity, that is a part of fundamental right under 19(1)(g). So how precious this right is, even at the age of social media, these provisions make it very clear. Now, as no right can be absolute, therefore there are restrictions on every rights. And the first restriction is, and these restrictions, mainly all the restrictions are available, is applicable on social media also. The extent might differ, and therefore it is necessary to understand these concepts. So another, the reasonable restrictions under Article 92 are provided. Now first restriction is that this right is available only to the citizens. So a foreigner cannot claim this right, fundamental right. In USA, this is not the situation. In USA, a foreigner can also claim a First Amendment right, which is provided under the Constitution of India. Free speech is available to all the persons. In our country, it is limited. It is limited to citizens only. All citizens can exercise it, but the foreigners cannot exercise. Second limitation is that corporations are not citizen. It was decided in State Trading Corporation versus Commercial Tax Officer, a constitution bench decision, that corporations are not citizen. So that way NDTV is a corporation. Dainik Jagran is a corporation. Times of India is a corporation. That is a product of Bennett and Coleman Company. Indian Express is also a corporation. So if they claim their right as corporation, they cannot claim it. But the Supreme Court has rightly decided that the stakeholders of those corporations, editors, promoters, readers, press reporters, they can claim their right, and therefore right to press has become a fundamental right way back in Ramesh Thapar, followed by Indian Express in many cases. But then there are limitations, which limitation is not available in the USA. Now there are 8 limitations which is provided in the Constitution itself. In the beginning, all 8 limitations were not there. Sovereignty and integrity of India, security of state, friendly relations with foreign states, public order, this is one group. And second group is decency or morality, contempt of court, defamation and incitement of an offense. These are provided and we all are aware of this. I am not going to deal it further. Now, in last maybe few years, the government has used certain powers to block social media under Rule 69A of the Information Technology Act, and the rules like Information Technology Procedure Safeguards for Blocking of Access to Information by Public Rules 2009. The government has blocked this much of accounts, websites and URLs. I think this is visible. 2014, 417 accounts, websites or URL blocked, and 2021 it goes to 6096 accounts, websites and URLs will be blocked. So this is certainly a cause of concern that number of websites and accounts and URLs are being blocked. Many people have raised concern that India is probably little aggressive in blocking such websites and accounts. Internet shutdown is also possible, and internet shutdown is made because of social media like WhatsApp. So Jammu Kashmir is one illustration where internet was shut down for 18 months. When we say internet shutdown, does not mean internet was totally shut down. It was available for essential purposes in Jammu and Kashmir. Of course, it was not available at home. It was available to limited places. Fast connection was not available, which was made available after maybe 18 months. In 2012 to 2022, around 665 internet shutdown has been made. Some studies suggest this. In Rajasthan, for the purpose of examinations, internet has been shut down because it has been found that WhatsApp as a means of unfair means it is being used. So it is done under certain laws, temporary suspension of telecom services, public emergency or public safety rules 2017. So public order can be a ground to shut down social media. Public order is provided in the Constitution of India. Similarly, so I will just discuss that there has been great criticism that India is little harsh on internet shutdown. My answer to it is that India is not harsh on internet shutdown. India is not harsh on blocking, because the threat to India is entirely different. Our borders are so porous, our borders are so dangerous. We have internal and external security measures. So in comparison to UK, in comparison to USA, take example of USA. USA has a population of 35 crore. India has a population of 135 crore. UK has a maybe geography which is not even equivalent to Uttar Pradesh. So we cannot compare UK, USA and maybe other countries, and our case is entirely different. And therefore I think that the internet shutdown or WhatsApp limitations on WhatsApp or blocking of certain websites are perfectly justified in the light of the fact that anyone who is aggrieved can not only approach to the executive body as a matter of appeal, but can also go to the High Courts under 226 and Supreme Court under 32. In the case of Jammu Kashmir shutdown, Anuradha Bhasin, an editor of an online magazine, a magazine, has approached the Supreme Court, and Supreme Court has ultimately held that internet shutdown was not bad. Of course, it needs to be regulated and it cannot be used arbitrarily. Then contempt of court. Contempt of court is another ground, and in the age of Twitter and WhatsApp, a lot of defamatory and contemptuous statements are being made. Twitter and WhatsApp and Facebook is full of such type of posts. One such example is Prashant Bhushan case, where the Supreme Court has held that his tweets were defamatory. His tweets were indeed contempt of court, and therefore he was held guilty for those tweets. Now coming to digital age, before I come to other theories that deal with it. Digital age is a new freedom movement. I have no doubts in telling this. Why digital age is a new freedom movement? Because it has developed a new rights regime. If you see this slide, you can find that I have tried to find 10 such rights. There can be more than such rights. There can be some overlapping also. First is the quick right to information. Now, right to information was statutorily provided in 2005. Prior to that also, certain judgments convey that right to information is a fundamental right, but then currently we have quick right to information. A Supreme Court judgment is delivered, and then within half an hour the Supreme Court judgment is on our WhatsApp, on our Facebook, on our mail. So it is quick right to information. Then second is, which is far more important, is immediate right to reply. So I'm reading Times of India. I want to reply because I liked that article or because I did not like the article. So I have a right to reply to that news report. I have right to reply. If some WhatsApp post is there, I can reply immediately my appreciation or my concern. So right to reply is a type of revolutionary right that we have received through social media. Third is, it is a platform to individual. So even one person, gone are the days that you were dependent on certain persons. One person can explore various possibilities, be it political, be it religious, be it individual, be it anything. So there is a platform for individual, so I can choose a platform for myself. Fourth is right to audience. I can choose my audience also. So I can restrict it or I can make it available to everyone. So I have a right to audience, and it is available to anyone who makes this type of who uses this type of platform. Then fifth is probably the most important for me, and that is that the digital age and the social media has made the whole discourse more inclusive. It has given more beneficial, it has been proved to be more beneficial to weaker section, more beneficial to the person who is voiceless, more beneficial and meaningful to a person who has no godfather. So take example of a person who is beaten by police, and then there is some recording takes place, and that is uploaded on the WhatsApp, and the government starts taking action. You can one of the recent example is the Tyagi case of Ghaziabad, where he has Mr. Tyagi, a political leader or alleged to be a political leader, has misbehaved with one lady, and he has bragged that he has great powers, and within fraction of minutes the video of misbehave was uploaded, and the government has started taking action, and then teams have been made, and he was apprehended. This was not possible 5 or 10 years back, unless you are a big person, unless the press takes it to themselves. But this is now possible. So it has become more inclusive and more beneficial to weaker and voiceless. Even if you don't have a godfather, you can find a way. Now, right to participatory democracy. Social media has made it possible. You can connect to the government. I can connect to the Prime Minister in Twitter account. I can connect to Yogi ji in the Twitter account. And in many cases, we have found that there are some information, some responses also. I don't know how many you have tested, but you can test the Twitter account of railway. If you lose something, if you find that the coach is dirty, you just tweet, and you will find that within few minutes, SMS will come back to you, and within 1 hour you will receive a phone call, and within 2 hours somebody will come to attempt that complaint. So that is how you connect with the government. You can connect with the media also. Then seventh is right to afford. Now gone are the days when freedom of speech and expression was a type of monopoly, which is the next point also. I can also afford, and you can also afford. And right from sitting in Ghaziabad, I can discuss with you all, and you at various places of India and maybe world, you can discuss with me. So there is no need to afford a flight or a train, and also to give more time. So this is certainly a revolutionary type of benefit to all of us. Then right against monopoly. Big players in the media, in politics, even in education, they all have been challenged. Media, they used to publish making a gang, they used to publish their own people, that gone are the days. In politics also, people used to make political party, but there is no requirement. Now the political parties can be made, and the support can be galvanized with the help of social media. And great movements, take Arab Spring movement in the world, or take Nirbhaya movement in 2012. So many movements have taken place without any political parties. One recent example can be maybe Shaheen Bagh, where political parties were not directly involved. People were involved, and the movement went for 2 months, 3 months. Of course, the Supreme Court has ultimately declared that it is unlawful, it is illegal. Similarly, in education sector, so monopoly of people have gone, and now it is possible that with the help of social media, we can educate, we can discuss, we can participate. So you want to pass a law commission report, you can pass through WhatsApp, through other social media. Many reports you can pass from one place to other place. So initially it was the sole jurisdiction of a few people, because it was available either to the libraries big libraries or to the metropolitan cities, but because of social media and the internet, now it is available to remote places. Right to explore talent. This is another significant point. So if you have a talent, you need not to look for Bombay. You need not to look for some very big people like some Mahesh Bhatt or like some big agency like Rajeshri Production. You can make your talent available to people, and in a fraction of day you become a sensation. I think you all remember this Chinia Badam, the song of Chinia Badam or Kacha Badam. The person, a matter of chance, he became a sensation. Similarly, lastly, social media has made it available that we can help each other, and COVID and Corona has shown it that we were able to help each other. I know that there are groups, there are associations on WhatsApp who exchange information about bloods. So this is the revolution that social media has done. Therefore, I say it is a new freedom movement. But everything is not, everything that shines is not gold, friend. There are a lot of bad news about social media. It has come to destructive outcome, and here the law and especially criminal law comes in picture. A lot of lynching was made possible because of the false news which was propagated in the WhatsApp. It was propagated like anything. Ultimately, WhatsApp has to understand, because take example of lynching in the name of cow, or lynching in the name of some child lifters. So take example of Maharashtra lynching, where 5 people were killed, including 2 sadhus. So after this incident, WhatsApp was told by the government to take measures, and then the WhatsApp has limited its facility of forwarding. Now we know that we cannot forward for more than 5, and the groups you cannot forward everything at a time. So second is that the WhatsApp and social media is full of lies, and sometimes we also become a part of it. Even I have seen many law teachers, sometimes law students, sometimes advocates passing of wrong information. So recently, when in the Nupur Sharma case, an order came that the petitions, the FIR cannot be clubbed together. 2 of the Supreme Court judges, they have given this order. The order may be right or wrong, and we also have right to criticize. But what happened? We have started attacking the judges. Indeed, wrong pictures were circulated that they are associated with some political parties. Indeed, it was found that wrong picture did not belong to Supreme Court judges. It belonged to some editor of a newspaper. So at least it is responsibility of at least the law students and law teachers that not to be a vehicle of those lies, and without verifying posts, we should not forward certain posts. So third is anti-national expression. Social media has become YouTube videos, social media, WhatsApp, that has become a source of anti-national expression, challenge sovereignty. That is one such reason a lot of website has been blocked by the government. Take example of the re-emergence of Khalistan movement. A lot of people from Canada, they are using the forum of Canada and agitating for Khalistan again. So anti-national expression, social media has become a platform for anti-national agitation, anti-national expression. Then it has become a source of radicalization and membership of terrorist organization. You need not to go to some religious place. You need not to meet certain people, some religious element. You can be radicalized by YouTube video. And if you remember the incident of Burkina Faso in USA, there were only 2 people, one husband and wife, and they have killed around 13 people, and they were radicalized by YouTube video of one Islamic terrorist organization. So social media has become a source of radicalization, and this is one of the greatest threat. Porn has been available for last maybe many years, but then Because of social media, it has become easier to access not only for us but also for children having 15 years, having 10 years of age, having cell phone with them, and the phone is available to them. Then corrupt practices. Social media has become a tool of other corrupt practices, various corrupt practices. Then social media is being used for affecting democratic process. Likes and unlikes and trends that the social media is propagating. Many of these trends are indeed choreographed. The campaign on Twitter, the campaign on Facebook, the likes on Facebook, they present a distorted picture that is a threat to democratic process. Then social media has become a place for hate speech against person, hate speech against religion, hate speech against community, hate speech against courts, hate speech against state. Social media has become a source of this. There are laws for that, but then the bigger problem is that intentionally or inadvertently the intellectuals are also becoming a part of social media hate speech, either by liking or by forwarding or by any other means. So these are 8 or 9 destructive outcome of social media. Now these are some of the news items which you can visit. You can either visible that BBC has reported how WhatsApp helped turn an Indian village into lynch mob. Now what are the restrictions? In the light of this, it is clear that there has to be a restriction on social media, and there are 2 tests for restriction. One is that the restrictions has to be reasonable. Restriction is provided does not mean the government can pass any restriction. The government does not like, therefore it can make any restriction. No, not like that. It has to be reasonable. So first is that you have to establish that the restrictions are reasonable. And second, if you establish that the restrictions are reasonable, then all restrictions of social media has to be on the ground of 1902 to 1906, which I have already mentioned, on sovereignty and integrity of India, maybe public order, maybe contempt of court, maybe morality and decency. So on these 8 grounds, the restriction on social media can be there. Now there are 3 reasonable restriction theories. That what is the meaning of reasonable restriction? There may be many, but I could find there are 3 theories. One is proportionate theories. Proportionate theory. What is this proportionate theory? Proportionate theory says that restriction have to be proportionate. Just because there is a threat does not mean you will use any restriction. It is something like that you need not to bring a big stone in order to cut in order to break a nut. अखरोट को तोड़ने के लिए आपको किसी बहुत विशालकाय चट्टान की जरूरत नहीं पड़ती. तो proportionate, this must be proportionate. The restriction must be proportionate. So you cannot keep on telling that internet shut down, social media shut down for maybe 2 months, 3 months, 4 months. It has to be proportionate. Second test is least intrusive test, or it is also known as narrow reading test. That the restriction must be narrowly tailored. It should be least intrusive. So it should not be very wide. And based on this ground, Shreya Singhal has declared Section 66A of the Information Technology Act as unconstitutional. If you go back to 1962, Kedarnath Singh, a case on Section 124A sedition, it also says that Section 124A is unconstitutional unless there is a tendency of violence, unless there is a tendency of disorder. So it has made it least intrusive. As possible, it should be intrusive. It should not be very wide. Third is, you have to show the necessity. Necessity is not a strong argument because ultimately it is the executive jurisdiction. But to some extent, you have to show that there is a necessity of doing it. So there is a threat. Does not mean you will say that no, you cannot be a part of WhatsApp media. You cannot use social media. You have to show the necessity for that. Let me give you a small illustration which is not for social media but general. That is Jantar Mantar case. In Jantar Mantar case, what happened that Jantar Mantar was a place where protest used to take place. So what the government has done, government has enforced 144 in the vicinity of Jantar Mantar and said that there cannot be any protest near in the vicinity of Jantar Mantar. If you want to make protest, we are giving you a place, and they have provided them a place which was far from certain place, which was far from public. The Supreme Court in Jantar Mantar case held that you cannot ban, you cannot say that Jantar 144 is applicable for all the time to come. No, you cannot say that there cannot be any protest in Jantar Mantar. You can restrict the number of persons, you can restrict time, but you cannot say that it cannot be because it is not required, it is not necessary to ban protest from Jantar Mantar. So because Jantar Mantar is a place which is in the vicinity of Delhi, executives, judiciary, legislature, all are nearby. So if you give a place which is 20 kilometers away, what is the meaning of democracy and what is the meaning of protest? So it has to be necessary. So friends, three of the theories which talk about reasonable restrictions or restrictions reasonable or not are: one, whether it is proportionate; second, whether it is the least intrusive; third, it is necessary or not. If not, the court can declare it unconstitutional. Now coming to the limitations. Now as I told you that no rights are absolute rights, so are, even if it is a human right. I have often heard that internet is a human right. People start talking internet is a human right and therefore it cannot be restricted. That is a complete misreading. Even not, what to talk about our fundamental right, which contains limitation under Article 19(2). Even UDHR contains limitations. UDHR Article 29 contains limitations for the purpose of or against freedom of speech and expression on the ground of morality, public order and general welfare. So if Facebook is going against morality, if Facebook is doing something which is going against public order, if the WhatsApp is doing something which goes against general welfare, restrictions can be imposed. Similarly, take example of Article 12 of ICCPR, International Convention on Civil and Political Rights 1966, enforced in 1976. National security is one of the limitation. On the ground of national security, a WhatsApp, a YouTube, a website can be blocked. It is provided in the human rights document. It is on the ground of public order, even on the ground of public health. Restrictions can be provided on general freedom of speech and expression and modern means of freedom of speech and expression like social media. So we should be aware that both restrictions and rights both are provided in the human rights document as well as in the fundamental right document, and those are equally applicable to all social media. Then I will discuss with you that there are three models of free speech. The first model is the American model, second is the British model, and third is the Indian model. And they are three different model, entirely different model. What is American model? American model is an absolute model. Absolute, why it is absolute? Absolute in the sense that there are no express restriction on the fundamental right to freedom of speech and expression. Freedom of speech and expression is provided in the US Constitution through First Amendment, and therefore it is also known as First Amendment right. But there are no express restriction, and therefore many experts say it is an absolute model, and therefore it is not correct to say that there are no restriction at all. Through Supreme Court of USA, various limitations has been developed, like police power doctrine, like clear and present danger test, like imminent lawlessness test. Many doctrines have been developed, but so far as the Constitution is concerned, there is no express limitation, restriction. That is why free speech is free speech. Idea of free speech is far liberal in USA than in India. Second is the case of Britain. Now Britain is a no fundamental right model, because Britain has no written constitution, and therefore Britain has no fundamental right. No fundamental right in the sense that Parliament can pass any law which cannot be declared unconstitutional. Of course, under human rights laws, they can be declared incompatible, but they still remain enforced. In USA or in India, a law can be declared as unconstitutional if it violates fundamental rights. So Britain is a type of no fundamental right model. They don't have it. They are still so conservative that they don't have any written constitution. Of course, it is wrong to say they don't have a constitution. By custom, by various provisions, by various recognition of their Supreme Court judgments, by recognition the parliamentary debate, they do recognize they have a constitution, but ultimately they don't have a written constitution where fundamental right is provided in the sense that fundamental rights if a law violates fundamental rights, it makes the law unconstitutional. This is not provided in the Britain. I will just show you how Britain is entirely different. I will come back to Indian model, but see, these are Article 10, Human Rights Act 1998, freedom of speech and expression is provided in the statute. But see the restrictions. You will find that what are the restrictions? There are 11 such restrictions. National security, territorial integrity. These are the restrictions in the UK. UK is supposed to be one of the very, very liberal country, but their restrictions are more than our restrictions. One more important thing that probably that will surprise you is see section 57 and 58 of the Terrorism Act. They say that if you surf any website, if you download any content which may be useful for terrorist purpose, you will be implicated and information can be registered by the police, and then a prosecution can be started against you just because you download a content which is useful. So suppose a content has come to your WhatsApp which shows how to make bomb and you have downloaded it, you can be in big soup, you can be in difficult terrain. Of course, this does not mean that every such case the prosecution starts, but this is the situation in USA. So sorry, UK. So UK, which is supposed to be very liberal, is not liberal in fact when it comes to law restricting social media, restricting free speech. Coming to the model of India, Indian model is a hybrid model. Indian model is a rights with restriction model, which I often say RWR. So British model is a rights model American model is a rights model, absolute rights model. You can say it is a R model. British model is a no R model, no fundamental right model. And Indian model is a rights with restriction model. Why rights with restriction model? Because in our constitution itself, fundamental rights are provided under Article 19 as well as restrictions are also provided under Article 19. So neither rights are more important nor restrictions are more important. In USA, it is said that rights are more important than the restriction. In Britain, it is said that restrictions are more important because parliament can do anything. But in India, rights with restriction, that means rights and restrictions both are equally important. We cannot say rights are more important or we cannot say restrictions are more important. Both are equally important. That is the difference between three model. When we try to regulate social media, we have to keep in mind three types of model. So the facility, the benefit which is applicable in America or not applicable in Britain, Indian case is entirely different. Now I will conclude with some of the theories of limitation. Some of the theories of limitation I will try to conclude in 6 minutes, and then for half an hour we can have discussion. I request you to post your questions and comments and agreements and disagreements in the chat box, and also feel free to discuss with me in the next half an hour. Now I will come to the first test. First test was developed in 1952, and this test is little known to many people, and this is known as the case of the name of the case is Shailbala Devi case. This is also Shailbala Devi was the state of Bihar. It was decided by a constitution bench, so it is very significant. 5 judges have decided this case, and it is also known as Bharti Press case. In this case, the Supreme Court has decided that the content cannot itself be inflammatory. Content cannot itself be objectionable or offensive unless you read the content in toto. In other words, मान लीजिए कि 15-20 लाइन लिखी ने फेसबुक पे किसी ने लिख दी है, तो 15-20 लाइन में अगर कोई एक लाइन लिखी गई है और बाकी की जो 10 लाइन है, बाकी की जो 15 लाइन है वो ऑफेंसिव नहीं है, तो इन टोटो the content will be said to be perfectly right and fundamental right is protected. Take example of a book. Suppose a book is written having 200 pages. Out of 200 pages, there are 2-3 pages which are highly objectionable. Only just because 2-3 pages are highly objectionable, we cannot ban the book. We cannot prosecute the person for that purpose. State at least cannot do it personally. So this is known as in toto test. In toto test means you have to read the tweet, you have to read the Facebook post, you have to read the WhatsApp post in toto. In complete content has to be read. You cannot pick up or choose up 1 or 2 content. And if there is a video, and in the video suppose the video contains maybe half an hour, and in the video there is 1-2 minute footage, and that footage is objectionable, that 1-2 minute footage does not make the whole video objectionable, offensive. In toto test developed by the Supreme Court in the Constitution bench says that unless and until the whole video is read comprehensively in toto, the video cannot be banned, the person cannot be prosecuted. The same happened in recent case of 2021 of Vinod Dua, where he had made some objectionable remarks, but the Supreme Court said that in toto the video is informative, it is critical, it may be inappropriate, but it does not violate fundamental right which is made on social media. So this is very important for us dear friends, because these days what is happening, that what we are doing is that we are picking up 1-2 lines, and a lot of such videos are coming to our WhatsApp. Only 1 minute video, 2 minute video, 3 minute video that Mr. such and such political party leader has said against Hinduism, such party leader has said something against Islam, such party leader has said against Modi, such party leader has said against maybe Rahul Gandhi. We have not seen the whole video, so we have to make a judgment only after seeing the whole video or whole content. So let us not forward those type of video which are just abridged, which are just video which are not complete video, because that such type of forward if we make, we are not fulfilling our duty provided in the fundamental duty chapter, which says to develop us a scientific temper. Second case which is relevant for social media is Ramji Lal Modi. In this case, section 295 capital A of the IPC was challenged. It deals with religious type of thing, that you cannot hurt the religious feeling. Now Supreme Court said, again the Constitution bench, that religious feeling is not something which is hurt by 1 sentence or 2 sentences, 1 criticism or 2 criticism, 1 likings or 2 likings. It has to be aggravated in form. तो किसी रिलीजन को हम नहीं पसंद करते और हमने कह दिया इसी रिलीजन के बारे में किसी की जो है ये रिलीजन को हम पसंद नहीं करते क्योंकि इसमें ये बात है, इसके कारण ही आप उसका प्रोसिक्यूशन नहीं कर सकते. ऑफ कोर्स यू कैन टेक सिविल एक्शन, यू कैन गो फॉर टॉर्ट, यू कैन गो फॉर डिफेमेशन, but you cannot prosecute under 295 capital A. So like in toto test, aggravated form test, people do not know, police does not know, political party leaders probably do not know, and they ask for FIR register karo, aadmi ko arrest karo. This is not like that. Nupur Sharma case, it is said that probably the video which was circulated, a small part of video was only circulated, and that small part circulated in such a manner, it showed that probably Nupur Sharma is speaking something which is very much objectionable. So it has violated in toto test because the whole video was not available, and secondly it has violated aggravated form test because if you see the whole video, it does not show that it was of aggravated form, but ultimately the court will decide. 1960 is another milestone, and this has become far more relevant for these days because advocacy on social media is very much prevalent. In Ram Manohar Lohia case, what Ram Manohar Lohia has done, that he has given a speech, and in the speech in 1960 he asked the peasants, asked the population, asked the people not to give additional tax. Additional tax were imposed on peasant, So they had to give extra amount of tax. So Ram Manohar Lohia said not to give tax. So he has made appeal to people that please do not give tax. So Ram Manohar Lohia was arrested and he had challenged the law. It was a UP special law and he had challenged it. The UP state said that tax is the liability of everyone. Tax is the responsibility of everyone. If the tax will not be given, how the country will run? So this advocacy that tax should not be given, therefore in order to stop him, we have done it. Supreme Court has given a beautiful judgment. It has declared the law unconstitutional. It has upheld the advocacy by Ram Manohar Lohia not to give tax. And the Supreme Court said that if people are not giving tax, tell me what is the problem happening. Under Article 19(2), there are 8 restrictions. First restriction is security of sovereignty and integrity of country. Whether advocacy of Ram Manohar Lohia has directly infringed it, whether he disturbed any type of maybe public order, whether he disturbed foreign relationship, whether he had gone beyond morality, decency, whether he has done something which is contempt of court, whether he incited people for committing any offense. No. Then on what ground his freedom of speech and expression, his freedom of movement has been curtailed? The state had no answer. Then the Supreme Court said that tell me, if someone does not give tax, what do? There is a revenue proceeding. If I do not give tax, then the revenue proceeding will be started. Income tax proceeding will be started. So those who are not giving tax, you start the proceeding, but you cannot infringe the right to advocacy, even if for a cause which seems to be unlawful. So Ram Manohar Lohia is a brilliant case which indicates that sometime maybe for little more unlawful cause and advocacy made, then that is protected. So advocacy for a cause is protected, but at the same time we should be very careful that advocacy for a cause is protected does not mean we start advocating Bharat tere टुकड़े होंगे इंशाअल्लाह. We start advocating बंदूक के दम पर लेंगे आज़ादी, because in first case Bharat tere टुकड़े होंगे, you are not talking about right to dissent, you are talking about right to disintegration. You are challenging the very sovereignty and integrity of country. When you talk about बंदूक के दम पर लेंगे आज़ादी, you are talking about violence, you are talking about बंदूक, you are not talking about peace. So advocacy for a cause is permissible, but only up to the extent it does not go what is the restriction provided under Article 19(2). 1961 is another constitution bench and another theory was propounded, and the theory was that the US test of clear and present danger is not applicable in India. US has developed a test in 1919, clear and present danger test, and it said that unless the danger is clear and present, fundamental right to freedom of speech and expression cannot be interfered. So it has to be clear and present. Babulal Parathe said no. Clear and present danger test is rejected by our framers of the constitution. It was a constitution bench judgment. It said that Dr. Ambedkar and his team has rejected this doctrine. We need only reasonable danger. If the danger is reasonable, even if it is not clear, even if it is not present, reasonable restrictions can be imposed on any freedom of speech and expression. So that is also applicable on social media. 1962 Kedarnath Singh case, which was on section 124A, has developed tendency test. What is this tendency test? Tendency test has become very significant in the age of social media. The tendency test suggests that if you do something, if you express something, if you speak something, if you write something for 2 days, if you forward something, if you post something which has a tendency of violence and disorder, underline the word tendency, not actual violence and disorder, but tendency of violence and disorder. If there is a tendency of violence and disorder, then you have violated, you have abused the freedom of speech and expression, and a prosecution can be started against you under various provisions. For this purpose, section 124A and maybe section 505, because 505 was also involved in Kedarnath Singh case. So it is a tendency case. So now please try to understand, there is a confusion. There are people who say that unless there is a evidence of actual disorder, unless there is an evidence of actual violence, the law cannot come in. No, that is completely wrong. That is a complete misreading of Kedarnath Singh case. Kedarnath says only tendency test, not actual violence case. So if someone posts something which has a tendency of violence, he can be prosecuted. His freedom of speech and expression can be curtailed, even if there is no violence takes place. I am skipping Ram Manohar Lohia test. Ram Manohar Lohia test is also a significant test, but I will go to K. Abbas case of 1970. There are two important cases, K. Abbas and Shreya Singhal. K. Abbas case, it was again a constitutional bench case, and in this case the Supreme Court held that the limitation which is applicable to books, pamphlet, newspaper cannot be similar as for cinemas. So there is no pre-censorship for newspapers, there is no pre-censorship for books. Similarly, if you say that similarly there should not be any pre-censorship for cinema, that is not possible. Why? Because they too form a different class. They are two different class and Article 14 is not disturbed. Why? Because cinema has great impact. That theory has become very relevant these days. Why? Because WhatsApp has great impact. So newspaper has impact only on those people who can read, who can study. But cinema has an impact on those people who can not only read but also can listen. But WhatsApp is available on the cell phone of everyone. It has a greater impact. So WhatsApp and social media create a different type of category. A third category, I would say. It creates a third type of category, and therefore restrictions are far more aggressively applicable on WhatsApp and social media and Facebook because of its reach, because of uncontrollable nature, because of impact, especially in the light of the fact that these days cell phones are available to the children who are 10 years, 12 years, 13 years age. Then I will just go to Anuradha Bhasin case because time I just want to conclude in 2 minutes. Anuradha Bhasin case, where the Supreme Court has declared that internet is a fundamental right, but access to internet is not yet decided. Please take note of. Internet is a fundamental right. Still, the restrictions which were imposed on the internet shutdown was held constitutional. Why? Because clear and present danger test is not applicable in India. 2020 Shaheen Bagh is a new case, and Shaheen Bagh is first important case where the Supreme Court has recognized the power of social media, and Supreme Court has recognized the social media and the toolkit. It has recognized toolkit and its power. It has great power. It runs in both direction. It is double edged. So it agitates a person, gives additional fundamental right to freedom of speech and expression, gives us various benefit, but at the same time it can galvanize support of people who have no leaders, who do not know what the law is, who may be misguided. Vinod Dua case I have already discussed. So friend, with this I conclude this part of discussion. I will just refresh that there are 3 types of model. One is US model, which is a far more absolute model.